All right. Hello, everyone. Welcome to week 13, which means we have approximately 2 weeks of material left after this week. So we are in the home stretch. Week 13 begins our final module of this class, which is looking at the criminal justice system um, and its response to intimate partner violence and domestic violence. So, we're going to begin our discussion this week with law enforcement, and let's kind of learn about law enforcement's response to domestic violence and intimate partner violence. As you read through chapter 12, it's packed with a lot of great information. So, as always, make sure you take notes. This lecture is a highlight lecture. It's not meant to cover all the material in detail. You will have this PowerPoint. I will also provide you with the publisher PowerPoint. Um, and I will cover the main aspects that I want you to know, but there may be some detail that you still need to know. So make sure you read. All right, with that, let's go ahead and get started. So, why is it important for us to look at law enforcement's response to intimate partner violence? Well, as you read in the introduction to this week, uh, historically, domestic violence calls have been some of the most dangerous calls for law enforcement over the years. Domestic disturbance cases require a substantial portion of law enforcement resources, and they are typically the largest category of police responses. So let that kind of sink in. Um, Law enforcement handles the majority of their cases being domestic violence cases. So it's really important for us to kind of sit and kind of take a look at how they're responding, what the danger is with these cases. You will read um, some statistics that are kind of staggering that I want you to kind of pay attention to on page 287 of your material. It says, looking at the years between 1996 and 2009, 771 police officers were murdered in the line of duty. And over that 14-year period, 106 of those deaths were identified as having been murdered while responding to domestic violence calls, which means that 14% of those deaths in the line of duty for police officers were them responding to domestic violence calls. 14% of police deaths in that 14-year time span um, was a result of domestic violence calls. And so that's why it's important for us to kind of look at this topic and discuss this topic. You'll see on here domestic violence related calls to the police account for between 15 and over 60% of all calls. So you're roughly, and that's a wide range. And it's a wide range because it varies state to state. But you see anywhere between, um, I would say probably 30 to 50% in most states. Now, there are some academic underpinnings um, of how intimate partner violence cases are handled. And so there's this diagram is a great diagram for you to reference. But between the 1950s and 1980s, police officers were trained to negotiate with parties and refer them to social services agency in a mediation process called the family crisis model. So, but in the 50s to the 80s, police officers operated under this family crisis model where it really was them kind of cooling the situation down and referring them out to different social services agencies. However, as you will see, in 1958, Wolfgang conducted a homicide study. And this is where we really kind of recognize that family crime could be deadly. And so then you have the Bard study that showed that family disturbances were finally recognized as major aspects of police work, and mediation was being used as the primary tool that police officers um, were utilizing. And so in 1981 to 1982, there was a study that you will be familiar with. It was called the Minneapolis Domestic Violence Study, or the Minneapolis Domestic Violence Experiment. And this was where law enforcement were given three options to uh, to kind of use on domestic violence calls. So they had the option to arrest the suspect, or order one party out of the residence, or they could advise the couple at the scene how to solve their problems. Well, the Minneapolis domestic violence experiment really kind of solidified the foundation of mandatory arrest policies, kind of spawned out of this project. So, in this project, law enforcement typically started arresting the offenders. And the findings out of the Minneapolis domestic violence experiment reported that when the suspect was arrested, there were statistically significant reductions in the number of reoffenses in the official record of the cases and cases where the victims were interviewed. So, in essence, the Minneapolis domestic violence experiment um, gave birth to the notion that you needed to have mandatory arrest in domestic violence situations. Now, there were 5 replication experiments to kind of um, see if the Minneapolis experiment would hold up in other areas. Well, those 5 replications disputed the original findings. So there were a lot of disagreeing scholars around how to handle these cases, because the Minneapolis experiment was initially held as like the standard bearer for how law enforcement should handle these cases, and literally spawned mandatory arrest policies. But then when you replicated, and when scholars replicated, they were getting mixed results in this. So finally, in 2001, Maxwell and some colleagues provided evidence supporting the argument that arresting male batterers may, independent of other criminal justice sanctions and individual processes, reduce subsequent IPV. So in 2001, Maxwell and his colleagues um, undertook another study and kind of supported the Minneapolis experiment's findings. Therefore, the arrest of the perpetrator, when probable cause exists, has emerged as the preferred response in most jurisdictions, and that is uh, being supported by Maxwell's findings, that arrest is associated with reduced recidivism. And recidivism is how we typically measure success in criminal justice. So you're going to read about police attitudes around domestic violence. And as you can see, from the 50s through the 80s, there was a lot of philosophical debate around what is the role of the police? Are they supposed to be mediators? Are they supposed to arrest everybody? Are they supposed to kind of try to find a happy medium? it really kind of varied. And so attitudes kind of emerged that have been studied by scholars. And these attitudes are important because it truly is going to be a predicator of how those officers treat IPV cases. So, the first attitude that's going to be discussed is what I call, this is a Mr. Dean phrasing, strict enforcement of the law. And this attitude basically does not deviate from what the law says. These officers' attitudes are formed and shaped by the law, and they strictly adhere to it. They don't see any gray area. Then you're going to see the role of the social services role um, for police officers. So some officers um, view that their role is to help, and in order to do that, they need to kind of be that mediator that they were in the 50s through the 80s, um, and kind of help resolve, kind of calm down the situation, and refer them out to varying service providers. And then there's a third role, which is the ideal attitude and role. And that is the integrated investigator. And basically, it takes the best of both of the previous two and marries them together. So this attitude um, basically says the officer follows the law, but also aspires to link the victims to the services that they need, or the family to the services they need. So you're going to read a little bit more about these roles, role attitude, role attitudes around the roles that they feel that they play. Sorry, that was a tough kind of wordplay. Um, Pay attention to this because, like I said, how officers view their role dictates and predicates how they handle situations. You're also going to read a lot about training and kind of some of the standards of training that officers receive uh, in regards to domestic violence. So, we know that three-quarters of police departments require specialized domestic violence training for officers, with training times varying. Um, but there's not real like uniformity. You'll read about some specialized units that receive more training on like interviewing and evidence collection, but not that's not the norm. And so we see a lot of police officers getting um, introductory training and things like that to domestic violence, and then some departments have integrated ongoing domestic violence training, and really that ongoing training is ideal because it kind of keeps the practices and procedures fresh in their mind. So police officers are there to uphold the laws. And as we are reading this week, the laws have evolved throughout time, and they constantly change with respect to arresting procedures. One of the unexpected consequences of criminalization of domestic violence has been the increased number of cases where both parties involved in IPV were arrested. This is known as dual arrest. And so you had the mandatory arrest policies that came out after the Minneapolis experiment, and it caused some ripple effects throughout um, the United States. And one of those ripple effects was this notion of dual arrest, where both parties were arrested because um, officers could not see who the primary aggressor was. And we'll talk a little bit more about primary aggressors here in just a minute, but um, dual arrest was one of those unintended consequences that had to be fixed. And so, in order for them to fix it, they evolved. Um, they evolved their arrest procedures. And so, let's take a look at some of the arrest procedures that are out there now. Typically, now, as a result of dual arrest and kind of um, trying to fix that ripple effect, we see that policies are now categorized into three different categories, and these are arrest policies. So you typically have your mandatory arrest policies, which require officers to arrest a person without a warrant based on probable cause that an offense occurred and that the accused person committed the offense. Mandatory arrest basically says that if you are called out for a domestic violence case, someone's going to jail. Then you have a category known as pro arrest. And pro arrest gives authority for an officer to arrest an individual without a warrant, but is not required um, to. They have the discretion, um, but their arrest is highly favored in those situations. And then the third is sole discretion, and the arrest is at the officer's sole discretion. Research has found that the odds of arrest in intimate partner cases increase by 97% with mandatory and pre arrest or pro arrest laws compared to states with discretionary laws. So, if you're in a state that has a mandatory arrest policy or a pro arrest policy, um, the odds of arrest in these cases um, are highly likely and increased by 97%. So, do you know if Georgia, um, which of these policies Georgia falls under? Well, let's take a look. Georgia falls under the officer discretion. So you can see the key here and kind of see where Georgia is. We have those parallel bars. We are officer discretion. But you can see that there are several states that have mandatory arrest, and then the ones that don't have anything in them are pro arrest. So we typically officer discretion in Georgia. Um, Tennessee is highly pro arrest. Florida pro arrest. Then you see South Carolina that has a mandatory arrest. So I ask you to kind of think about, and we're not going to discuss it here, but kind of think about how do you think neighboring state laws kind of affect our state laws? All right. So we've talked about primary aggressor a little bit. Let's dive deeper. The primary aggressor in an IPV situation is the person who is responsible for the perpetration of the violence, not necessarily the one who initiated um, it, the situation. It's the one who physically did the violence. Primary aggressor determination should not include who started verbal arguments. Verbal provocation is not justifiable cause. Um, and primary aggressor laws offer guidance to police officers. There are laws that kind of are called primary aggressor laws that are meant to kind of help guide police officer decision making. And it kind of helps them determine who the victim and who the offender is. This involves using standards other than gender or size of the individual involved. That's very important. Primary aggressor laws and guidance does not take into effect gender or size of the individual. Officers typically consider who poses the most danger to the other and who is at most risk for future harm. Those are two questions that they typically ask themselves. who poses the most danger, and who is the most at risk for future harm. So I've linked some videos this week in Folio that I want you to watch. Some of them, one of them is a frontline video. It's a little bit older, but it gives a good kind. It's about a 20-minute video that gives a good kind of um, visual for law enforcement and dangers of law enforcement in responding to these cases. And then one is from one of my favorite shows, which is Live PD. It's just a situation where they're responding to a domestic violence situation, and you can kind of take what you've learned through this week and apply it to that. I think that video is about 7 to 10 minutes. You can actually see the thought processes, see what they're doing, all of that. But at the scene of a domestic violence situation, the officer has certain things that they have to do. And these are the four main focuses that the officer has. So, number one, they have to determine whether medical care is necessary. That is their number one priority. Then, after they've determined that, they investigate to determine who the perpetrator is and who the victim is. Because then they're going to have to interview. And we'll talk a little bit about interviewing here in a minute. There are certain procedures they have to do for interviews. But then they're going to assess the level of risk for injury to the victim. So they're going to interview after they've determined who the perpetrator is and who the victim is. They're then going to interview them. And when they're interviewing the victim, they're going to do a risk assessment. And you're going to read about the different questions they ask during the risk assessment in the readings this week. Pay attention to that because um, that can be a very informal process depending on the experience level of the officer. But it is something that every officer does at these scenes. And then finally, they're going to collect evidence. And you're going to read about the three types of evidence that they collect. Please make sure you are aware of the three types of evidence that officers collect at the scene of these domestic violence situations. Then, after they've done all of that, they're going to ask themselves, do I arrest or do I not arrest? And depending on the policies of the state, so whether they're mandatory, pro arrest, or discretionary arrest, they then kind of um, utilize that to answer these questions. So these are 5 questions that police officers must consider when making arrest decisions. 1. Does the action constitute a crime? Is there a crime? And what I'm witnessing or what I'm gathering, the information I'm gathering, does that tell me that there was an actual crime committed? And if there was a crime committed, is there probable cause? And we're going to talk about probable cause, but probable cause has to be established for an arrest to happen. And then they're going to ask if there is a crime and if there's probable cause to say that a crime occurred, what classification of crime occurred? Excuse me. Is the crime a misdemeanor or is it a felony? And then does the officer have the warrantless power of arrest for this crime? Depending on probable cause, it's going to kind of, the Fourth Amendment dictates probable cause and search and seizure. And arrest is a form of seizure. And so there are certain exceptions to warrants that we'll discuss. And so does the situation fit into the exception to getting a warrant, or do they have to get a warrant for the arrest? And then finally, is there an outstanding protection order that has been violated? So at the very end of this presentation, we're going to talk about protection orders. But they have to, in these situations, determine, is there already an existing order of protection? Because if there is, then I have to determine if that's been violated. And if that's been violated, does that constitute an arrest? All right, so let's talk about probable cause. Probable cause is the standard of proof that must be satisfied for any search and seizure to occur. The Fourth Amendment of the Constitution governs search and seizure and probable cause. An arrest is legally defined as a seizure and therefore falls under the same requirements for probable cause as a search. So, in order for an arrest to happen, an officer has to have probable cause under the Fourth Amendment. So, what are some sources of probable cause? How do they determine if they have probable cause? Well, they follow the collective knowledge doctrine. They gather knowledge about the suspect's behavior. They can take into consideration some reliable hearsay and observations. These are all sources of probable cause. That and your book kind of details them a little bit more. The probable cause requirement covers searches as well as seizures conducted by government officials. Strict adherence to federal and state constitutional guidelines is imperative to obtain evidence that will withstand the scrutiny of the court. So remember, when an arrest is made, the case starts building, the court case starts building. So officers can't violate constitutional amendments, Fourth Amendment, Fifth Amendment, Sixth Amendment. They can't violate those amendments, or evidence can be thrown out. And so, um, they have to maintain adherence, and they can't deviate from those rights that the accused has. They will begin searching with valid warrants, um, or they may be in a situation where they fall into an exception to having to get a warrant. Most of the time, getting a warrant, um, is the standard, um, to ensure that there is um, no issues. However, sometimes they may not have time to get a warrant, and their situation may fall under the exception to the warrant requirements. So let's look at the exceptions. If someone gives them consent to search, freely and voluntarily, they don't have to get a warrant for that. Exigent circumstances and domestic violence. Police routinely enters homes for domestic violence calls, and they can investigate without a warrant during those situations. Search incident to a lawful arrest. If a person is placed under arrest legally, they can be searched. And then there is this notion that's known as the plain view doctrine. And plain view seizures, basically are articles may be searched if in plain view in public places where police have a legitimate right to be present. That's a biggie. They have to have a legitimate right to be present in order for the plain view doctrine to kind of kick in. So if they were called to a home under to investigate a possible domestic violence situation, they have a legitimate right to be there. And so if they see something in plain view, they don't have to have a warrant for it to be a search. Hope that makes sense. All right, so let's switch gears. We've talked about probable cause. Probable cause you should have got already been familiar with, so it's just a really quick overview. Let's kind of go back to the scene of a domestic violence situation and talk about interviewing. The best method of interviewing is to separate the parties and question them individually. So remember when we talked about child abuse and I gave you kind of talked to you a little bit about child abuse investigations, we always interviewed privately and separately to allow for free disclosures. Well, that was a practice that was taken from law enforcement because law enforcement in these situations will interview parties separately outside of hearing range from the other to kind of give each party comfort knowing that what they said, the other person won't hear them and they might feel more comfortable disclosing. Um, Interviewing can be extremely long processes. Um, and crimes involving intimate partners aren't really easy or quick because the victim may not recognize that they're a victim yet. However, it is very important for you to realize that standard procedure in these law enforcement investigations is to interview separately and privately outside of hearing range of others. So now let's talk about orders of protection. Uh, you'll hear them called different things. I've always called them protective orders. In my practitioner life, we always dealt with what they were known as protective orders. And these are court orders that restrict or prohibit one individual's behavior in order to protect another. Generally, they include provisions restraining contact, prohibiting abuse, intimidation, or harassment, and prohibiting the possession of firearms. I did not go over this in this lecture. However, you need to make sure that you read the laws governing firearms with domestic violence perpetrators. There are several laws that kind of limit the ability of perpetrators to have firearms. And so make sure you pay attention to that section of the reading material because there are prohibitions for domestic violence perpetrators. Protective orders can also prohibit the possession of firearms. And then these are orders that really kind of um, help keep victims safe in the eyes of the court. And they can also award temporary custody of minor children in protective orders, or you hear them called TPOs, temporary protection orders. Um, so a judge can find that um, the victim, let's say Johnny beat up Linda, and Johnny and Linda have Johnny Jr. And Johnny Jr. was home. So Linda goes and gets a order of protection against Johnny for beating her up. The judge can kick Johnny out of the house, award Linda temporary custody of Johnny Jr., and prohibit Johnny from seeing Johnny Jr. and from being around Linda. All of that can happen in a protection order. And it's important that we go back to one of those fundamental questions that law enforcement officers ask themselves in these situations to see if there was one of these orders of protection already in place, because we know that victims typically don't leave on the first go round. And so I have been in situations where there have been active temporary TPOs, temporary protection orders, um, and the couple goes back into their honeymoon phase. And so they're actively violating the TPO um, whenever another incident happens. All right. So finally, we've talked about the full faith and credit, but we're gonna just kind of highlight it here again. Um, when talking about TPOs, uh, what happens? if the victim moves to a different state? Well, there's something known as full faith and credit. Um, and this is a mandate that basically states that a state must enforce another state's protection order, even when the enforcing state would not issue such an order itself. States have implemented this provision by including the language of full faith and credit in their own statutes and codes on domestic violence prevention. While not required, registering an out of state order puts the protection order on file in the new jurisdiction for the purposes of expediting a response in the case of an emergency. So, under the full faith and credit mandate, essentially, um, those TPOs are interstate wide jurisdiction. So, um, Georgia would honor Alabama's TPOs under full faith and credit, or Michigan would honor Georgia's TPO under full faith and credit, even if Michigan would not have issued an order itself. So you're going to read about the interstate component of protection orders. Know that normally um, all states operate under full faith and credit. All right, that's going to do it for this week's lecture. Again, make sure you read, watch the videos I've posted, and if you have any questions, feel free to reach out. Hope you all have a great week, and if you need anything, holler.